This video is edited to shorten watch time by removing sidebars, procedural evidence handling, and long pauses. Witness testimony remains intact, with minor trims to hesitation words and stutters. Audio is enhanced from the broadcasted court feed, but some originally inaudible dialogue may still be unclear.
Can you state your first and your last name, and please spell both your names for the record?
Christine Remsburg, CHRISTINE
And Ms. Remsburg, how old are you today?
33.
I'm going to show you what's been marked as State's Exhibit 42. In the meantime, Ms. Remsburg, while this is being done, have you ever been convicted of a crime?
Yes.
And how many times?
3.
Ms. Remsburg, I'm going to show you what's been marked as State's Exhibit 42 up on the screen. Do you see that picture?
Yes.
And do you recognize that individual?
Yes.
What is that individual's name?
Zachariah Anderson.
Do you see what that person's wearing in terms of above the waist clothing?
Yes.
And how would you describe that outer garment?
His flannel coat.
Is that something that you recognize as a item regularly worn by Mr. Anderson?
Absolutely.
Is this an item that you ever came in possession of? In other words, after 2020, was this either left at your house or ever something you had?
A couple times, like when he would stay over, it could have been left at the house, but I never took it to him or anything like that, and I don't know where it is.
Have you moved from the house you lived at back in May of 2020?
Yes.
And was it at your house when you moved?
No.
So you do not believe it was left at your house after your relationship with Mr. Anderson was over?
No.
Is the person you've identified as Mr. Anderson, is he here in the courtroom today?
Yes.
And could you point out where that person's located and what they're wearing? What is the person wearing?
He's wearing his blue suit.
Can you give me a description of any other item?
His tie.
And what colors are the tie?
Blue and red.
I'd ask for the record to reflect the identification of the defendant.
She's indicating the defendant.
Ms. Remsburg, during the period of May 19th, 2020, were you over at the defendant's home in the evening hours?
Yes.
How did you come to be at his home on May 19th?
He invited me over for a movie night.
And how many times do you believe you had been to his house before that?
Around 3 times, occasionally.
And on the 19th, when you were present, did you see something happen to Mr. Anderson? In other words, was he removed from his home?
Yes.
So what happened to the defendant?
He got arrested.
Okay. And how had you gotten to his home on the 19th of May?
I drove the 2009 Audi.
I'm going to show you what's been marked as State's Exhibit 1, Photo 271. It's going to go up on the screen. Just tell me if you recognize that item when it comes up. Do you recognize that?
Absolutely.
What is that?
The Audi.
And you drove that, and whose car was that in May of 2020?
Zachariah Anderson's.
How did you come to be a person driving that over to his house on May 19th?
I didn't have a car due to a car accident I had, and I needed a way to get back and forth to work when I was able to go to work after COVID.
Prior to May of 2020, how much earlier than that, how many weeks or months or years before that, did the defendant give you his Audi to drive, to be your normal transportation?
That was the first time.
For how long though? For
4 to 6 weeks.
About 4 to 6 weeks
Yes.
from the date of his arrest?
Yes.
During that period of time, did you have that car on a everyday basis because he had lent it to you?
Yes.
Okay. So what vehicle, if you know, did the defendant drive during that period of time?
His minivan.
So I'm going to show you what's been marked as State's Exhibit 1, picture 254, and ask you if you recognize that particular vehicle.
Yes.
What vehicle is that?
That's his minivan.
That's the minivan of the defendants?
Yes.
So while during that 4 to 6 week period, you were driving the Audi, to your knowledge, what vehicle was the defendant driving on an everyday basis?
The minivan.
The one I've identified in this picture?
Yes.
How often were you in that minivan during the time period of April and May of 2020?
Not very often.
What sort of circumstances would cause you to be in the minivan?
It was probably before that, but just going to the grocery store.
I'm going to show you what's been marked as State's Exhibit 1, picture 263 for just a moment. If I told you that's the back of the same minivan, do you recognize the carpet being removed from that minivan? Did you ever see the van like that?
No.
On May 19th, 2020, when you were present at the defendant's house and he was arrested, what was the status of your relationship, if any, with the defendant?
We were dating.
How long did you believe, or do you believe you had been dating the defendant prior to that time of May 19th, 2020? How long had this been going on?
About a year, give or take.
About a year?
Yep.
And how often were you seeing him, let's say, per week during that year?
4 to 5 times a week.
And when you say you saw him 4 or 5 nights a week, what did that mean? So in other words, what was going on?
He would come over shortly after I got done with work or whatever was going on with his day. We have a movie night, spend the night, and we take off to work and do our own thing in the morning.
Okay, so I want to be sure I have this right. May 19th, 2020, you're saying, give or take for about a year, the defendant's been coming to you, you guys have been spending the night together 4 or 5 nights a week. Is that accurate?
Accurate, yes.
How many of those nights did you spend at his house? Of those 4 or 5 nights a week, how often had you spent the night at his house?
It was always my apartment.
Okay. When's the first night, if ever, that you spent a night at his house?
I never spent the night over at his house.
Was the plan that you were going to spend the night on May 19th?
I don't know if that was the plan. It was just being invited over for a movie night. But yeah, at the time, yes, I would.
You believe so?
Yeah.
Okay. Where were you working during that period of time?
Libby, Montana's.
Now, on May, so that was a Tuesday, May 19th, that he was arrested. When the defendant was arrested, did law enforcement then also speak to you?
Yes, the same night he was arrested.
Okay. And did they want to know about the previous Sunday? So 2 days earlier, 2 nights earlier.
Yes.
They were kind of focused on that, weren't they?
Yes.
And what did you originally tell them that you believed was the whereabouts of the defendant on the evening of May 17th, which would be that Sunday? What did you originally tell them?
What I originally told him is that he was over, but like I told them when they look on my phone, it says on my way, he was over. And if it doesn't, he wasn't there that day.
So originally you said you thought he was over there.
Yes, originally that's what I said, yes.
And did you tell him you thought he came over around 6 o'clock after you got off work? Is that what you told him originally?
Yeah.
Did you tell him, and then he never left the house? Did you tell him that's what you originally thought?
Yes.
And did you say he stayed until about 11 a.m.? Is that what you originally told him?
Yes.
Okay. Now, did you also mention to him that there was another person who might be even a better source on whether he was at your house or not that night? Did you give him another name of somebody who might know even more or be more sure?
What do you mean by that?
Well, did you mention that your sister might be somebody who would even know more information or be more sure about it?
Yes.
Okay. Ultimately, did the officers come back to you?
Yes.
And re-question you about the 17th? In other words, what had happened 2 days earlier?
Yes.
Okay. And when they did that, did you decide that, in fact, he had not been at your house on the 17th?
Yes.
Okay. And is one of the things that happened is that you went through your phone, or that there was phone evidence where you could tell that he had not come over?
I'm going to object as far as leading.
At some point, did you share phone evidence with law enforcement?
Yes.
Okay. I'm going to show you what's been marked as State's Exhibit 164.
Oh, I can't read that. Sorry, I don't have my glasses with me.
Is this hard for you to see?
Yeah.
Okay.
I'm
So
so
if,
excited.
Ms. Remsburg, if you have to get closer to be able to see it, please let us know, okay? That'll be okay. We'll have you hold a microphone. Judge, do you still have that microphone up there if she needs
I
it?
don't. Oh, That's right there.
Oh, I'm sorry.
It's got to be turned on. May I have it, please?
Oh.
Well, you're younger than me. You probably can turn it
I'll
on.
let you.
First try. Very good.
So, and I'm going to approach this close enough so okay. So, did you receive a text from Zachariah Anderson's phone to you on your phone at 4:57 p.m. on Sunday, the 17th of May, where he says, cool?
Yeah.
Okay. And then at 6:35 p.m., do you text the defendant's phone and suggest to him you got a movie in mind?
Yes.
And so does that text, is that a text you sent him?
Yes.
Okay. And with that, so you don't have to read it. Does the text, is that all right if I just read it as opposed to making her read it?
Fine.
Okay. Does the text at 6:35 p.m. to the defendant say from you, Alice in Wonderland, Land 1933, gotta find it and watch it. It's my new mission M. Do you see that?
Yes.
Okay. That's a movie that you're discussing?
Yes.
And are you expecting the defendant at that time to still show up at your house?
Possibly, yes.
Okay.
I was.
I mean, you had plans with him,
Yes.
did you not?
Yes.
Okay. And so you are suggesting for our movie night, here's what I'm thinking.
Mm-hmm.
Yes?
Yes.
Okay. Any response from him at that time?
No.
Okay. Now I'm at 9:20 p.m. Up to then, have you received any texts from him or calls from him since you told him, hey, the movie's Alice in Wonderland? Has there been has he been in touch with you in any way?
No.
Okay. So now at 9:20 p.m., you text him and you say, get to keep kiddos tonight? Is that true? Did you text that?
Yes.
And you're at 9:20 p.m., right? When you send that, 9:20 p.m.? Okay. Still no response until the next time you text at 10:31?
Right.
Okay. At 10:31 p.m. or 10:31:09, do you text the defendant, whatever, going to bed?
Yes.
Okay. Fair to say you're not happy at that point?
Yes.
Okay. And is the first time you hear from the defendant a text from him that says, fell asleep, sorry, missed afternoon nap? Is that what he said?
Yes.
Okay. And then, after that, did you receive a call from
I'm going
him?
to object to leading again.
That's sustained.
What, if anything, can you say about later whether you got a call from him?
Yes, I don't remember the whole phone conversation, what it was about, but usually we just talk about our day or how we feel and what's going on.
All right. And did he ever arrive at your home that night?
That night, no.
Okay. On the next day, so Monday morning, were you again texting back and forth with the defendant?
Yes.
Okay. And so I'll ask you if you recognize this text. Can you read that text? It's going to be a long day. Still haven't got to work. Hit you up later.
I'm going to object at this point. I'm going to ask that he ask a question and she responds.
Well, I'm reading the text. These are stipulated records. I'm reading them and asking him, is she familiar with them?
I'm not sure if you're suggesting that this is becoming a narrative or you're objecting to this as being leading or something.
Well, one, it's leading. Two, it is a narrative if he's just going to be reading things and at her. And not sure what the relevancy is of reading every single text message between them. So if there's a question about a particular text that he has, then I would ask that he ask that question.
Well, I think he can make his presentation. The objection is overruled.
Okay, so again, I'm going to read it just for purposes of you not having to approach. I'm going to read you the content of the text again.
Okay.
It's going to be a long day. Still haven't got to work. Hit you up later, babe. Is that a text you received from the defendant's phone on a time period that is noted as 8:54 a.m.? Is that a time you received that text?
Yes.
Okay. So when the defendant texted you and said, I've had a nap, and so that's why I haven't answered any of your texts, you don't know for sure if he had a nap.
Objection leading.
This particular question I don't think is suggestive of a particular answer.
I think it is, because I think the proper question, Judge, would be, when you received that text, did you know exactly what Mr. Anderson was doing?
Well, that would be a better version. I'll grant you that. But I don't think it's one where there's particular concern about coaxing the witness into a particular answer. So the objection's overruled.
Did you know one way or another whether he was taking a nap when he texted you or had been?
How could I? I was at home.
Okay. And when you received the 8:52 text indicating that the defendant had not yet arrived at work, you had no idea where he was, did you?
Absolutely not.
On that Monday, after the text that said, "I'm not at work yet," do you recall when the first time you saw the defendant was on the 18th? Like, what time did you first meet up with him in any place? Your place, his place on the 18th?
Was that Tuesday?
It was a Monday.
Tuesday.
So, what?
Was it Tuesday?
It was a Monday. Only if you know.
I don't remember. I just know on Tuesday is the movie night, and I was over there around 7.
Do you remember telling law enforcement that on May 18th, you went to his home about 6 p.m.? So that would be the Monday that you also
Oh, I'm just confusing dates. Okay.
Did
yes,
you do that on
was Monday.
on Monday?
Yes.
But were you also there on Tuesday, the day he was arrested?
Yes.
Okay. On the 18th, when you went over to his house, so that's that Monday, did you have the Audi that day as well?
Yes.
I have no further questions.
Let's examine.
Thank you. Good morning, Ms. Remsburg.
Hi.
So I want to go back a little bit. The state had been talking to you about the first statement you gave law enforcement on the 19th, and then the second time you talked to them 2 days later. You had told law enforcement on the 19th that you had memory problems, and that's why it would probably be better to ask your sister, right?
I didn't specifically say that I have memory problems. No, but considering me and my sister lived together and I was going back to work and I do have shit drinks. So no, I'm not good at remembering dates, but knowing my routine. And that was what I told the authorities.
So, but when you told them that, it was because you weren't 100% sure.
Yes.
Okay.
Because usually he was over there. The only time that he wasn't over there, either we were working or he was with his kids.
And so then on the 21st, which was 2 days after you first spoke with law enforcement, you told them, after seeing more information, that he was not at the house on the 17th, correct?
Correct. And when I got asked and I thought he was there, I even had them look at my phone. So for them to say that I lied or I was covering up and harass me about it is not right. It's not okay.
Because you weren't covering anything up, correct?
No, I was just going by memory. I got hit that my boyfriend's in some kind of trouble. I asked the captain what's going on and he couldn't even tell me. I didn't know until later on at all, nothing. And everybody feels like they're attacking me from authorities from this way and this is going on. No one really cares about what I go through. I didn't want to come back here because of the harassment I've been through. And I'm here.
And it's because law enforcement never really wanted to hear your story, right?
Exactly.
You felt like they were pressuring you into what they wanted you to say.
I just felt they were thinking I was hiding something, pulling something when there was nothing there to pull.
Because when you were with Mr. Anderson on those days and talked to him, there was nothing suspicious, right?
Objection. Calls for hearsay, Judge.
The objection, well, it's leading.
This is cross-examination.
Right.
So I can lead.
Yes, you can. That was in first year of law school.
Yeah.
That was a long time ago. Yes, you're correct about that. Well, the objection's overruled.
Do you want me to re-ask the question?
Yeah.
I just said that during the times from May 17th to May 19th, 2020, when you either saw or were talking to Mr. Anderson, there was nothing suspicious.
That's an argumentative question based on my new understanding of what argumentative objections are in the courtroom.
I'll rephrase it.
It asks to make a conclusion, and it's an argument.
The objection is sustained.
When you spoke with Mr. Anderson on May 17th, 2019, correct?
Yes, I believe so.
And the text messages before that the state had read to you about Mr. Anderson taking a nap, you remember receiving that text?
Yes.
And you said you had been dating Mr. Anderson for about a year?
Yes.
And during that year, I'm assuming you've known Mr. Anderson to sleep.
Yes.
And were there times where he would also nap?
Yes.
So receiving a text that he was napping, that wasn't anything out of the ordinary from your experience.
No.
And it's true too that during your entire relationship, there were times where perhaps you had planned on meeting up, but then that didn't happen because something else came up.
Yes.
Like sometimes Mr. Anderson would have his kids.
Yes, the schedule would change with the kids often.
And sometimes he would be tired from work.
Absolutely.
So it wasn't bizarre that he wasn't able to come over that evening.
Judge, again, this is propensity evidence and it's an argument.
It's actually a follow-up of the state's questioning of her.
Objections overruled.
You can answer that question if you remember.
Could you repeat it?
Yeah, of course. I said that there was nothing bizarre then on the 17th about him not coming over because he had fallen asleep.
No, it's not bizarre, no.
And when you talked to him, there was nothing out of the ordinary about the conversations that you had with him that evening, correct?
It calls for hearsay. It's the words talked to him are in it.
I'm not asking what he said.
The objection's overruled.
It's a characterization of a conversation. Apologize, Judge, but I do think
it's a characterization, but it is not seeking what is asserted in the conversation to prove the truth of it.
would have to be based on things that this defense attorney are not allowed to bring up. So it is hearsay. If you say, I don't want you to say what was said, but I want you to tell me whether the conclusion was X, Y, or Z from it, and the whole basis of it is verbal or is something that was said, that's hearsay. The defense is not allowed to bring that up.
I agree with that, but I don't think that what is being asked here is demonstrative of that.
The question began with based on what he said, and then the question was draw a conclusion based on what he said. What he said is hearsay from that side of
the objection of heart is not whether the witness drew a conclusion. It's if you offer the conclusion or the underlying statement to prove the truth of the matter asserted, which would make it hearsay. I'm not going to argue about it anywhere.
Okay.
Yeah, overall.
Thanks.
Was there anything suspicious about that phone call?
Can you repeat your question? Sorry.
Sure. I'll repeat it in full. The phone call that you had with Mr. Anderson the evening of May 17th, 2020, there was nothing suspicious about that phone call, correct?
No. I would have remembered something otherwise. To me, it was just a normal phone call. I don't remember exactly what we talked about even then. It's usually around the same thing. It was nothing I need to put on the schedule, so why would I?
And then you spoke with him, and then the next morning he texted you that you texted him, and then he texted you back that he was heading to work, right?
Yes.
And was that normal from your observations of Mr. Anderson that he would go to work in the mornings?
Yes.
And you were aware that Mr. Anderson was doing construction contracting work at a home up in Belgium, Wisconsin.
Yes.
And your understanding, where was Mr. Anderson going to work on that morning when he texted you?
I'm not really sure because the boys always did side work and that's the boys' thing, you know.
You knew that he was working at that home around this time?
I don't know if it was that day, but I knew they were working on that project. Yes.
Okay. While you dated Mr. Anderson for the year, did you know him to have any sort of injuries?
Like what type of energies are you talking about?
Like any sort of things that would prohibit him from moving around freely, any back problems, leg problems, anything of that sort?
He has back problems.
Okay, can you explain what you know of those back problems?
Sometimes he just can't move. He either has to lay there or he has to stand up and just keep doing stuff. It's serious pain enough to where you hold your back and you can't move.
Okay, and did you ever see him when he would have these moments of back pain?
Yes.
Objection irrelevant. Whether she's seen other moments unrelated to this time period, it's irrelevant.
Overall.
How frequent did this happen?
Same objection.
Overall.
How frequently did Mr. Anderson experience back pain and issues?
It was daily. Sometimes it was worse. Sometimes some days were better.
And do you remember if there was anything that would cause him to have back pain?
Heavy lifting that he would end up doing.
Okay. And to your knowledge, was it hard for Mr. Anderson to do heavy lifting because of his back issues?
Yes.
So you had gone over to Mr. Anderson's house from May 18th and on May 18th and May 19th?
May 18th and May 19th, you said?
Yeah.
Yes.
And when you were there, Mr. Anderson, was he with you?
Yes.
And you never saw Mr. Anderson with bloody clothes, correct?
No.
And did you ever see him getting rid of what appeared to be some sort of evidence?
No.
Was it just a normal weekend and day for you? Like how he was acting and what you guys were doing?
Objection. Council Monday would be the 8th. It'd be a Monday. 18th and 19th. Monday, Tuesday.
Okay, so when you, I apologize. Sometimes us lawyers get our days mixed up too. When you were together on Monday and Tuesday, what were you guys doing?
That's what we normally do. We sit around and talk and just enjoy each other's time. We eat. I would cook breakfast.
Okay. So there's nothing out of
the ordinary at all.
Okay. On the 19th, so that would have been the Tuesday when you were there, the day Mr. Anderson got arrested. Do you remember people coming to the house?
I sat in the living room. He told me there was trespassers, so I sat in the living room, acted like I was playing a game on my phone. I knew he was on the phone as either his dad or his brother. And then he called the police, and we went to meet the police in the driveway. I remember that day like it was yesterday.
Okay. Why don't you talk a little bit more about what you remember?
Okay. Again, Judge, the objection is that it's not a specific enough question because it potentially calls for hearsay in its general form. So I'd ask that it be more specific simply to prevent hearsay from being presented. Because what the defendant told her would be hearsay.
So, if I may respond, the first question I asked her was, May 19th, what do you remember about two people coming over? And she said she remembers that day vividly. So then I just asked her, well, what do you remember about that day? That's a fair enough question.
So she's already, I apologize, finishing.
I didn't ask about what any statements were said by Mr. Anderson. I'm simply asking her what her recollection was of May 19th, 2020.
And
Yes, go ahead.
her answer to the initial question was what included a couple of things that he told her. Okay. So to ask the general question again, to ask to have her be more detailed about the general question does not preclude the hearsay. And I'm just, hold on just a minute, Counsel. I'm just trying to make sure we're a steward of not presenting the evidence that's not permitted. If I was a lay witness and I heard, and I had just reported, here's what happened, here's what somebody said, and then I was asked, can you tell me more about that? I would, of course, go back and report those things again. The first question did not call for that, but the answer included it. And so now, from the state perspective, to be a good steward and try not to present hearsay evidence, we simply have to ask that the question be more structured.
In order for hearsay to be hearsay, it has to be a statement that's used for the truth of the matter asserted. Anything that, if I may, Judge, thank you. Anything that Mr. Anderson told her about sitting down and then her going in and sitting down would be an effect on the listener exception. I'm not looking to seek any of that into evidence, nor do I think that's what's been elicited here.
It's my interpretation he is making a precautionary objection to prevent hearsay from seeping into the record. You've inquired about the event, and there was reference in the witness's answer to conversational matters. That is an area of high risk that the witness will stray into something that would be hearsay. He hasn't claimed that there's been hearsay. I think what he's asking for is more like abandonment of the narrative type answer and ask specific questions.
Sure.
So as to reduce the risk of hearsay.
Sure.
So there's nothing for me to sustain or overrule other than I think it would be prudent. And let's try that route.
I just want you to talk about what you personally saw. Does that make sense? Not anything that Mr. Anderson would have told you?
Yes.
So in what you personally saw, did you see people who were trespassing on Mr. Anderson's property?
No, because why would I step out of the house in danger where there's trespassers? When there's a man there calling the cops, the woman should stay in the house and be protected.
And did you feel protected by
Yes.
Mr. Anderson? And in your whole year of dating Mr. Anderson, did you always feel protected by him?
Yes.
Your relationship with Mr. Anderson, it was relatively serious, right?
Yes.
You guys had very strong feelings for each other.
Yes.
Did you ever feel like Mr. Anderson was not trying to date you?
No.
And were you aware of of who Mr. Anderson's children's mother is?
I didn't know what she looked like, but yes, I knew her name and I respected their relationship and him doing his best to be a single dad.
Okay. I have no further questions, subject to recross.
Ms. Remsburg, you were asked a question about whether there was any reason for you to believe that you were not in a serious relationship with strong feelings for each other. What, if anything, can you tell us about whether you were aware of any texts or meetings or efforts by the defendant to get back together from January of 2020 through May of 2020 with his ex? Were you aware that he was making efforts?
He did have a dinner with her and he did tell me about it. about where the relationship fell apart, if it's better to get back together. He knew I was willing to let him go, but he showed me that's not what he wanted.
So he was telling you, I don't want to get back together with her during that period of time. That's what you were hearing?
Yes.
Okay. And you indicated that the defendant sometimes had back problems, but you also knew he worked as a contractor, right?
Yes. Well, any man that's older, everyone's got backgrounds, but he has some severe backgrounds where he would have really bad days like you. Do you have really bad days and really good days with your back?
I, in fact, do. Yes.
Yeah.
So there were good days as well.
Yes.
Okay. And then sometimes when heavy lifting happened, you are aware that the defendant would have to call and get some assistance for that. If he did some heavy lifting, he would need to get
I
some
wouldn't
care.
be aware because I wasn't at work with them.
Oh, okay. I apologize. I thought you said that you knew that then he sometimes got help for it if he had heavy lifting.
No, I wouldn't know because I wouldn't be working with them.
Got it. But sometimes after heavy lifting is when he appeared to have that back problem. Is that
Yeah,
right?
of course, when someone you're seeing comes over, you can tell when they've been in pain because they hurt their back from work or something that day.
Okay. So you indicated that on the 18th and 19th, nothing seemed out of the ordinary to you. When you saw him on that Monday and Tuesday, nothing seemed different.
Nothing to send any red flags, no.
Okay. So now I want to turn your attention back to a time period around April 24th. So just a few weeks earlier. Okay. During that time period, were you also have overnight with him 4 or 5 nights a week?
Yes.
Okay. And did you notice anything out of the ordinary during that period of time?
No.
And now I'm going to turn your attention to May 8th and ask on May 8th, right after, in that week or time period, right after May 8th, were you seeing him 4 to 5 nights a week?
Yes.
And was there anything out of the ordinary in his conduct or how he acted towards you or anything during that period of time?
No.
What about May 13th? Immediately after May 13th, did you have anything that happened that seemed out of the ordinary in your mind?
No.
You indicated you had heard and knew that the defendant worked as a contractor. Were you aware that he was also making money in the growing and sale of marijuana?
I'm going to object. It's argumentative and non-relevant to this case, Judge.
So I want to make an argument about relevance.
I'd like this to be heard outside the presence of the jury.
I guess it's time for you to leave us alone. How about a little break? Don't talk about the case during the break. Read, watch, or listen to any account of the trial. I'm going to say let's say 20 minutes. 20 minutes. I'm told one of the jurors threatened to bring a stopwatch.
Should she leave the stand for the
You
period of
can.
time?
I am going to write something.
We'll take a 10-minute break and then we'll come back. I think Mr. Gridley will go first.
The question I asked was whether Ms. Remsburg has knowledge of a significant marijuana grow operation taking place at the defendant's home that she's at those 2 days.
Right.
So from the state's perspective, this only becomes relevant under a line of questioning where Christine Remsburg is asked, during this relationship, have you noticed anything suspicious? During these time periods, is there anything that was out of the ordinary or something that you believe is suspicious? So at this point, a very valid argument from the defense would be Ms. Remsburg, who's in a long-term relationship with him, knows him well, spends 4 or 5 nights a week with him, is a purported witness that based on what she knows about him, that there is nothing alarming or suspicious in his conduct that she is observing of. So her quality as an observer certainly now is an issue. Here's my offer of proof to the court so the court knows where I'm at. She accompanied the defendant to a court hearing on a South Dakota drug case that the defendant had pending during this case. It's a
Judge, sorry to interrupt. No, this is not, it's more of a technical thing. Just because we might be discussing other witnesses' testimony, things of that sort. Ms. Remsburg's in the courtroom. I would just ask for purposes of this discussion that she not be present due to the exclusion order.
I agree with that. I think it's probably best that she not hear the discussion. Yeah, I think that's fine. Yeah.
I wasn't aware there was an exclusion order, but that's fine.
There was.
Well, I mean, I guess maybe once or twice. I'm aware that Ms. Remsburg actually accompanied the defendant to the South Dakota, to a hearing, a substantive hearing on that drug case in South Dakota. The allegation in that South Dakota case which the defendant, I believe, had pled to and was pending sentencing when this case occurred, when our case occurs, Judge, is for more than 10 pounds of marijuana. So she's aware that it's a significant case. You know, it's not the end of the world, but a significant case. She's present for that. And then while that proceeding is going on, while those court proceedings are not concluded, there is significant evidence of a substantial marijuana grow at this location. So not only is there the potting soil with marijuana accoutrements that the court saw in terms of the bags that were there, but this search warrant found about 2 pounds of marijuana at the defendant's residence, an operation where there's a process by which you either liquefy or tar the marijuana. This is one of the ways marijuana is produced and sold to individuals. That operation, there's a significant evidence of. There's an entire box or container of labeled seeds, which are marijuana seeds. They have their own sort of handwritten labels of the different categories or types or brands or, I guess, strains of marijuana that are in there. Olivia, the 12-year-old daughter in this case, is able to identify the exact number of plants that were being grown and describe in detail that operation. So I only give you that as an offer proof because I believe Ms. Remsburg would testify she's unaware. I'm not saying that I would bring up all those details. I'm simply indicating I believe she would say, I'm unaware that this is occurring, that there is a marijuana grow occurring. From my perspective, that piece of evidence indicates to a jury whether she is a credible witness, not about lying, but about her degree of actual knowledge about the activities of the defendant that he doesn't wish to share with her. So the most positive side of his nature. Again, it's only relevant because the defense has asked her a series of questions, how close they are, and then nothing suspicious. You saw nothing. At that point, whether she is a accurate or clued in observer to his activities, I think is directly relevant.
Thank you, Judge. Last time I checked, there's not a single count before this jury for possession of marijuana, possession with intent, manufacture, not a charged offense. It is a charged offense for the exact 2 pounds of marijuana and grow operation in 20 CF 151 in Ozaukee County. That's still a filed only status case. Given that there are no charges in this case pertaining to drugs or marijuana, any evidence that the state's attempting to elicit for that is, one, not relevant, but more importantly, falls under the curtails of a prior bad acts motion or another acts motion. That if the state wanted to get into information that is charged information in an open case that's not relevant to the charges here, but they wanted to use it for some purpose, then that motion should have been brought. When asking about suspicious activity, it was about why we are here, not about drug growth or anything like that. And even if the state wanted to try to use that to try to impeach or bolster a position, they still can't use other acts evidence to do that. There's proper evidentiary channels that the state has to go through in order to admit that type of evidence against Mr. Anderson, and they failed to do that. Throughout this trial so far, there's been multiple references or attempts of references to this grow operation, the marijuana fertilizer that was tried to come in yesterday through Detective Anschutz. But now to be going into whether she was aware of Mr. Anderson's dealings with marijuana is wholly irrelevant. It cannot come in as it's other acts evidence that has not been decided on.
It doesn't appear to me that it is being offered to prove what you just said, that is any activities of the defendant with respect to marijuana. And that's actually the target of the rule, the other crimes, wrongs, and acts. The rule is actually a rule against showing other behavior of the accused or any other person, but to show that he acted in conformity with a character trait or something. He's not even close to trying to do that. He suggests the reason he is doing it is to demonstrate that Ms. Remsburg does not have the wealth of knowledge that was suggested in your examination, or it could also fall upon her believability. That is a little bit more circuitous route because of well, as you correctly said, it's an extrinsic matter. So I don't want to touch that too much other than to suggest that from what the jury's already heard, there's reason to believe that there were opportunities for her to have seen things that were, what was your word on your examination? Suspicious?
Correct.
Yeah. That would be suspicious now. Maybe not suspicious with respect to the case involving Mr. Gutierrez, but it would be suspicious. I walked in here one day and there's a big jar of marijuana seeds. That'd be suspicious. I don't see it yet. I definitely do not see this as evidence of other crimes, wrongs, and acts, and definitely not being offered to prove any character trait of the defendant.
If I could be further heard, then why even ask the question if it's not relevant or going to some point that the state's trying to go to? But under 90403, the defense would maintain the position that even if the court would find that this isn't other acts and that it can go to her credibility, that introducing this type of evidence would be prejudicial to Mr. Anderson.
Well, that's an issue as to whether or not I need to give a curative instruction. And particularly in this day and age when so many states are altering their laws and the governor wants to hear, it doesn't bear the social scorn that it once did. I don't think the risk of taint is so great, but I definitely don't think it's being, we can lose sight sometimes of what the real purpose of the rules of evidence are. And this particular rule, what is to be avoided is introducing evidence that the defendant is reprobate, has a character trait or bad character, and to try to offer that to prove that he's acting in conformity with that. That's not even close to what the state is attempted to do thus far. And to the extent that they would, I can assure you that there would be extensive discussion as to whether I should let it in. Those enumerated exceptions are directly relevant to the thrust of the rule, not to whether there's some casual reference to marijuana that is prohibited by law being available for easy sight under the control of the defendant.
So a couple things, Judge. First, this is an attempt, how I view it, is this is an attempt from the state to continuously use Mr. Anderson's alleged marijuana dealings. This is not the first time the state's brought it up. He's going to bring it up again. The state just admitted to you that he intends on doing it with Olivia Anderson.
Yes, and I commented the other day, and several times I commented, I don't have 1% of the knowledge you folks have about what the evidence in the case shows. Are you suggesting that at some point the state is going to introduce evidence of drug manufacture or dealing as motivational in respect to this charge?
I think what they're attempting to do is to introduce this so that the jury itself can make an inference about people who deal with drugs. And although, sure, this state, are we on a different trend towards the legalization of marijuana? Sure, it's still illegal. And there still are a lot of people who have very strong feelings about people who manufacture THC products and deliver marijuana. Not to mention, given that we're not here on a drug case and there was no other acts case, we did not voir dire on this issue. So I don't know if an individual on our jury has a bias towards drug dealers.
I'm going to look at this case differently if there's some suggestion that the defendant was involved in this incident, if he was involved. I'm talking now about what the district attorney is thinking rather than what I'm thinking. But if there's a suggestion that the state is trying to prove that the conduct attributed to the accused in this case was motivated by something to do with drug trafficking or manufacture or sale, that would make a big difference. Although it would also make it more likely the evidence would be received. In the absence of that, then I think it's a casual matter, which in terms of the 404, and I don't think it's objectionable.
I'm going to stand by the point of that it is prejudicial, especially since I didn't voir dire on the issue. since we were given no notice that the state would be going into these types of
Well,
other
did the
acts.
state
And
have knowledge that the witness
because
was going,
one of the,
did they have knowledge that the witness was going to testify as she did?
yes, she's testified
That's about
consistently.
suspicious. You
But
opened the door.
When we have a case where you're in a case where you know what the charges are and what the evidence is, when I'm asking about whether something's suspicious, the reference was to this particular matter, why she had been investigated. She was never investigated about Mr. Anderson's alleged drug dealings. She was investigated dealing with the suspicions of Mr. Anderson's dealings with Mr. Gutierrez. And I not once asked outside of a curtail of other suspicious activity that didn't have to deal with this case, nor did the answer elicit anything that didn't have to deal with this particular case. Back to my issue about the jury and not knowing certain biases, if I knew the state was going to be introducing evidence or attempting to introduce evidence to paint my client as a drug dealer, I would have questioned the jury on who here thinks that drug dealers kill people. Because there's a lot of people that have that thought.
So that argument's been repeated a couple times to the court. So the court's heard that now. That's the third time I've heard that repeated. So I want to make a record of just sort of where I believe the revisionist history is being declared to the court. So the first time, first of all, no opening part of any statement indicated anything about marijuana or the substantial evidence and during the search warrant found of a large quantity of marijuana or the search warrant. The first time this came up was when defense, cross-examining Detective Anschutz, asked him whether they believed his primary source of income was as a contractor. If the court remembers, I indicated that I wanted a sidebar. Does the court recall this?
Right.
I asked that I wanted a sidebar because it was important to me that that door not be opened unless counsel really wished that to be done, because I'm aware that the defendant is alleged by his daughter and that the search warrant appears to confirm the basic facts that he was growing 72 marijuana plants. I'm also aware that 72 marijuana plants, when I did drug cases a few years ago, is $72,000 of tax-free money. So there's no way his primary income or his income, when that is the type of operation we're talking about, is as a contractor. Rather than have the detective who was at the search warrant potentially answer that question truthfully, which is, well, no, I think his primary source of income is this, I tried to head that off. Now, counsel changed the question then, right? Asked the question specific to, is part of what this defendant does as a contractor. That appears to be the case, right? So that was me trying to be cautious. The second time I brought this up, Your Honor, was again on cross-examination of Detective Anschutz. She asked about a number of bags up against the barn. I think there are maybe a dozen bags there. And Detective Anschutz was asked, did somebody go through this? As if this is an inadequate investigation, as the court has heard me talk about several times. Well, those bags are the potting soil and the remains of, from the state's perspective, the 72 marijuana plants that his daughter says has just been harvested just before this case. That's why that potting soil, it's consistent in terms of what a grow operation would look like. So the true answer is no, we didn't spend a lot of time in those bags because those bags are X, Y, and Z. That would have been the true answer. And that was the first time the door was open. Now the court's already heard my argument about why Ms. Remsburg is not a valid or a appropriate reporter of whether there are suspicious circumstances going, because I believe she will offer, even though I was at a court appearance of his and knew that he had a marijuana case that everybody was concerned about, I had no idea that he had a marijuana grow operation while I'm seeing him 4 or 5 nights a week. That's not the degree of knowledge where a jury should feel like it's reliable to say, well, she didn't see anything suspicious, therefore we should adopt that in any way. And that's the current state of the cross. I think the court's made its ruling. I don't want us to continue to repeat arguments, but I did want the court to know I feel we've had a number of circumstances that opened the door already, and here we are.
Not repeating my arguments, making a legitimate full record, very different. As far as the testimony that's come in, Ms. Remsburg stated that they hung out 4 to 5 nights a week at her house, not his house. That really, as the state nicely pointed out, the only time she really spent there was a couple of days around this time. That the majority of the time, she's not there. So Additionally, if he's trying to say that she's aware of his South Dakota marijuana case, and then she's aware of the fact of what his dealings are with marijuana, so if someone's already aware of that, it's not going to be suspicious. If the state wants to go down this line of questioning, it
depends on what the witness understood question to be asking.
Sure.
Well, it could have been probed, and it still can be. You've both got an opportunity to question or more. But as Mr. Gravely has so eloquently stated, I've already ruled. I don't see this as objectionable. So to the extent you're objecting, it's overruled.
Well, I'd then ask that there be limits placed, because I want there to be a record that if Attorney Gravely goes into this in any other sort of situation, that there are going to be firm objections coming from this table, Your Honor.
Yeah, I mean, I think we'll get there when we get there.
I said I'm not going to squelch you. She can make her objections.
Sure. Yeah, I think we'll get there when we get there. I intend at this point, if she says I had no knowledge of it, then I think I have to show that this existed so that, you know, it's not a fantasy. And maybe they want to skip to the circumstances I've talked about. Maybe they want to say, yeah, he grew, you know, but it's not real unless, I mean, it doesn't mean anything to a jury unless after she's questioned, if she says I knew nothing about it, well, then I have to do something substantive to at least say that, you know, what's in the bags that you've pointed out. And, you know, I don't think, certainly it doesn't need to be extensive. And I understand I can't make character arguments about it. I have to stick to where the door's been opened. So we'll get there when we get there.
To that point, that he still needs to lay a foundation. Did you ever go in the basement of Mr. Anderson's home? That hasn't been testified to.
I'm not going to pre-screen what may or may not happen. If you feel his presentation is deficient, then you can enter an objection, as you've indicated you will,
right.
And then I'll rule on that. But at this point, I've overruled your objection, and if you like, I'll give the jury a short instruction now that they've heard some mention of growing marijuana, and that's not relevant to this case. I don't want to say that. He's not charged with that. He's not on trial for that, and it's not something that ought to be considered in terms of any wrongfulness of that behavior.
I think what I will do is not ask for that instruction at this point, Judge, because it may just call more attention to the issue.
Makes sense.
What I may do is ask for cautionary instruction 274, other conduct at the end of the case, which I think would address this issue. So that would be the defense's position on that.
And that's fine. And the only thing I'm going to say on that, I probably will, when you get the preliminaries, it'll probably be in there, but if it's not, better object.
To the 274.
Request is
requested.
Yeah, requested.
Understood.
Okay. Anything else? All right.
You were aware of the defendant involved in a row of marijuana plants at his residence?
No, not at his residence.
You had no knowledge of that?
No.
You've been to South Dakota with the defendant in the months before May of 2020. Hold on, let me finish. As he was going through court appearances on a marijuana case in South Dakota?
Yes, I was there for one of his court cases to be there for support.
Okay. And to your knowledge, had that case concluded by May 19th, 2020, or was it still going?
It was still going. He had another court date, and then he got arrested for this case.
Okay. So knowing that case was pending, in a relationship with the defendant, as you have described, you have no knowledge of a grow of marijuana at the defendant's home during the same time period as that court case and as the rest of this?
No.
I have no other questions for Ms. Remsburg. Thank you, Your Honor.
Thank you. You may step down, ma'am.
Okay, thank you, Your Honor.